this presentation is from Miss Tecla Spiller, who is a law student. She was taken ill and she can't speak at all this morning. So that's, she sent the slides for us to use. Let me just share my screen. Right, we had some information, very valuable information from James McCarthy yesterday, but he touched on intellectual property. But this is meant to give more of an overview, more of the background of the legal framework in which we function, or in which creatives function. I think a lot of artistic people don't actually know all about this, and there's a need to know about it. And maybe even us from these more scientific sectors don't know enough about the legal aspects. So this is about intellectual property, culture, and the creative industries. And it will be introducing IP, intellectual property and indigenous knowledge systems, IP and computer gaming, and IP and artificial intelligence. Right, WIPO, the World Intellectual Property Organizations, under the United Nations, 1967, when they were formed. There is a link, and this presentation will be available on our website. The rationale for adoption and protection of IP is twofold. A, to give statutory expression to the rights of creators and innovators in their creations and innovations, balanced against the public interest in accessing creations and innovations. To promote creativity and innovation, so contributing to economic and social development. IP law is a property right that relates to intangible property. In quotations, intellectual property refers to creations of the mind, such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. IP is protected in law by, for example, patents, copyright, and trademarks, which enable people to earn recognition or financial benefit from what they invent or create. Relevant forms of IP: copyright, protect the form of the idea. WIPO, literary and artistic creations such as books, music, paintings and sculptures, films and technology-based works such as computer programs and electronic databases. And then creative content is also subject to copyright. Industrial property protects the idea itself through patents. It includes patents and trademarks and traditional art forms. I think it's meant to be industrial intellectual property. So that has to do more with the ideas and the inventions, the innovations. These are some key acronyms. CCI is Cultural and Creative Industries. IKS is Indigenous Knowledge Systems. ICE is Indigenous Cultural Expressions. TCE is Traditional Cultural Expressions. And GR is Genetic Resources. The importance of, let me just see what that was again, cultural and creative industries and indigenous knowledge. Globalization and global trade were creating consequences of social exclusion, cultural homogeneity, and environmentally unsustainable patterns of growth. Creativity and culture are plausible responses to these challenges. Right, we're still battling with that even in the science sphere, where we are excluded sometimes despite our very good scientists, and where it becomes a challenge to apply for funding, for example, from international bodies. And this applies to all of Africa. Arts and culture are socially transformative tools. I think this is an important point because it has to do with the expression of artists which are representative of society, but also society's problems and the struggles that people have. And they can actually highlight what is wrong with the world, but also inspire what can be right, or how we can deal with it, like Mbongeni's work. Also, economic importance of CCIs. First, international trade in cultural goods and services have been growing at a faster rate than overall international trade. And digital technologies and the global internet are important drivers of this growth. Second, under Engel's law, cultural consumption is positively correlated with economic development. So this is about the importance of the creative industry. I think we sorely neglect the cultural goods and services that is part of our traditions and our backgrounds. And we have really neglected them, but they also suffer from the legacy of apartheid, where the cultural goods and services were not appreciated. So it's only in our South Africa since 1994 that I think there's been a revival of that appreciation. And yet still, it is in society, there is an undervaluing of cultural goods and services. Indigenous knowledge. Indigenous knowledge means knowledge which has been developed within an Indigenous community and has been assimilated into the cultural makeup or essential character of that community, and includes knowledge of a scientific or technical nature, knowledge of natural resources, and Indigenous cultural expressions. The eligibility criteria for protection applies to IK, which has been passed on from generation to generation within an Indigenous community, has been developed within an Indigenous community, and is associated with the cultural makeup and social identity of that Indigenous community. I would just like to remind you of something that Professor Mawala said yesterday. He's also written about it, that he used to watch his mother when he was a child, and his mother did pottery. She made pots from raw clay, and she would tap the pots, and that would tell her where the bubbles were, and that she had to make the walls of the pot more solid. And he was inspired by that knowledge that she had invented herself or acquired traditionally. And that we need to appreciate those kinds of things, the knowledge, the abilities, the skills that are already in traditional environments among our families, relatives, and in environments that we don't value enough. Traditional cultural expressions means expressions having cultural content developed within Indigenous communities and assimilated into their cultural makeup or essential character, including but not limited to phonic or verbal expressions, musical or sound expressions, expressions by action, and action tangible expressions. And there is a link to the Department of Arts and Culture, the publication, the legislation that includes these definitions. Public attitudes to Indigenous knowledge systems. The World Health Organization states that in Africa, up to 80% of the population uses traditional medicines for primary health care. I don't know if that is still true. I heard this statistic a few years ago, so I'm not sure, but from certainly from anecdotal evidence that is true. I read People's Plants, which is about the kind of flora that is significant for traditional communities all over South Africa. And there are so many that are still used for treatment of illnesses, indeed for primary healthcare. 2009 South African Social Attitude Survey findings indicate a positive attitude towards IKS, which serves to support the idea that IKS can be a leading contributor to South Africa's progress and development. More than half of South Africa's Africans, 53%, believe that modern science does more harm than good. 2/3, 66%, felt that IKS offers lessons that can benefit everybody. 71% felt we trust too much in science and not enough in Indigenous knowledge. And 72% stated we trust too much in science and not enough in cultural beliefs and practices. 3/4, 76% of South Africans feel that government should do more to document IKS in South Africa. The majority was in favor of the government doing more to support communities involved in IKS, to promote small business using IKS, and to spend more on protecting IKS. The majority, 60%, felt that big businesses are exploiting the Indigenous knowledge of communities and that government should be proactive in this respect. The issue of tension, the University of the Western Cape's Science and Indigenous Knowledge Systems program link with decolonization of knowledge systems, but how available for use should Indigenous knowledge be? And there's the question of exploitation by international big businesses. These are interesting questions. I have also heard that Indigenous knowledge for healing works because of the traditional practitioners, the healing practitioners, and they, in interaction with their clients, make these herbs work. Now, that is an interesting thing. This is also secret knowledge and sacred knowledge. And so it is quite a dilemma, not only legally and economically, but also culturally. Tensions between intellectual property and Indigenous knowledge systems. IP is around rights of the individual, whereas much cultural knowledge is collective. The idea of fixation is a problem in copyright application because so much of Indigenous knowledge is oral. IK is usually intergenerational rather than pertaining to one lifetime. Protection of IK through IP is very costly and burdensome. The focus of Intellectual Property Laws Amendment Act, the IPLAA, that is an act of 2013, it used standard IP concepts such as copyright, patents, etc., but not fit for purpose when dealing with Indigenous knowledge. Therefore, the IK Act of 2019 was effected. It does not replace it, but alongside it. So that is quite a recent development, 2019. And that act is Protection, Promotion, Development and Management of Indigenous Knowledge Act. The Protection, Promotion, Development and Management of Indigenous Knowledge, the establishment of functions of the National Indigenous Knowledge Systems Office, which is NIKSO. If I'm not mistaken, that is hosted by the Department of Science and Innovation. The management of rights of Indigenous knowledge communities, the establishment and functions of the advisory panel on Indigenous knowledge, access and conditions of access to knowledge of Indigenous communities, and facilitation and, I can't actually see that, apologies, facilitation and coordination of Indigenous knowledge-based innovation. So this is what the Act establishes. How does the Act protect Indigenous knowledge? The IK Act protects IK through the concept of sui generis. It translates into English as of its own kind or unique. The Act therefore breaks down the traditional IP distinctions between, for example, copyright of works of art and patents for crafts, using the concept of sui generis to incorporate all forms of IK. So in intellectual property law, you have these two divisions, the private rights and sui generis. Private rights have to do with economic benefits, individual ownership, limited term protection of private rights. And there are the tools, which include copyright, trademark, Performance Act, industrial design, and then there are criteria under that. Sui generis is about economic benefit, moral benefit, and customary benefit. It is about collective ownership, perpetuity, and the tools are folklore, databases, genetic resources, and Indigenous knowledge. The criteria is that these must be embedded in a local community in an intergenerational context. So it's interesting how our law has actually been adapted to the real needs that society has, rather than sticking to the traditional way, or the, no, we're getting mixed up with terms here, the usual way of protecting property, intellectual property rights in Western developed countries. The Department of Science and Innovation. This act was essentially about redress and bridging Indigenous knowledge into the mainstream. This was also a transformative act because it addressed how Indigenous communities could contribute and become part of the mainstream economy using their own Indigenous knowledge. The department, of course, was the driver of this new sui generis legislation. So these are some clauses. Clause 9 provides for the subject matter under protection within the meaning of Section 25 of the Constitution. In addition, the subclause provides for Indigenous knowledge as property vesting in the relevant Indigenous community. Clause 10 provides for the duration of protection of the subject matter, which will persist for as long as the eligibility criteria set out in Clause 11 are met. And then Clause 11 delineates the eligibility criteria for protection of the subject matter, namely Indigenous knowledge, which has been passed on from generation to generation within an Indigenous community, has been developed within an Indigenous community, and is associated with the cultural and social identity of that Indigenous community. Clause 12 affirms custodianship of Indigenous knowledge eligible for protection that vests in the trustee of that Indigenous community who holds the Indigenous knowledge in trust on behalf of the Indigenous community and responsible for and accountable to the Indigenous community for the protection of their rights. Clause 13 provides for Indigenous communities holding Indigenous knowledge to have the exclusive right to any benefits arising from its commercial use, be acknowledged as a source, and limit any unauthorized use of the Indigenous knowledge. This act is available on that link, and as before, this presentation will be available on our website. Next topic is IP and computer-generated content. That will be addressed as computer gaming and then artificial intelligence. Computer gaming, the Patents Act of 1978 in South Africa provides that, among other things, anything which consists of a program for a computer or a scheme, rule, or method for performing a mental act, playing a game, or doing business shall not be an invention for the purposes of the South African Patents Act. How then do we protect computer video games in terms of intellectual property? There seems to be a contradiction in the legislation here, where on the one hand, IP legislation should protect such inventions, computer video games, etc. And yet the Patents Act of 78 rules that they cannot be protected. Computer gaming. Modern computer games contain at least two main parts: the software and the audiovisual elements. The software, which technically manages the audiovisual elements and permits users to interact with the different elements of the game, it cannot be patented, but code can be copyrighted. Audiovisual elements, including pictures, video recordings, and sounds, and you can use copyright to protect that. Copyright Act of 78 comprises the following video game elements. It refers to musical works, storyline or literary works, artistic works, coding, characters, box design, and website design. It is a negative right that grants the holder the right to authorize others to reproduce a work or prevent them from doing so. Artificial intelligence. In 2016, in quotation marks, the next Rembrandt. Artwork created by a 3D printer, which analyzed hundreds of well-known Rembrandt paintings and used the machine and deep learning techniques to mimic the 17th century Dutch artist's works. So, although I haven't seen this itself, this program, The Next Rembrandt, what I have read about is that that hundreds or thousands of paintings are, pictures of them are fed into a database, and the artificial intelligence analyzes that database and distills the common elements in all those paintings and then composes a new painting. So it really penetrates the knowledge of Rembrandt, and it gathers what kind of painting he was doing, what his methods were. So that's a very interesting one. This is a collaborative effort between ING Bank in the Netherlands, J. Walter Thompson, Amsterdam, Microsoft, and innovative Dutch entities, TU Delft, Mauritshuis, and Rembrandtshuis. I think we still have a representative from the Dutch embassy in the audience, so I really would like to ask her to comment on this when I've finished. But it was the AI-powered machine that created the work. So who is the owner of the copyright in and to The Next Rembrandt? In the United States, the rules regulating the US Copyright Office state that the office will register an original work of authorship, provided that the work was created by a human being. It will not register works produced by a machine or mere mechanical process that operates randomly or automatically without any creative input or intervention from a human author. Similarly, in the 2012 case of Acronyms Pty Limited versus UCorp Pty Limited, the Federal Court of Australia declared that a work generated with the intervention of a computer could not be protected by copyright because it was not produced by a human. artificial intelligence in South Africa. An AI algorithm, or more specifically, the written code, encompassing both the source code and object code, would be categorized as a computer program under South African laws and is protected by the law of copyright, but not by patent. In the law of copyright, ownership of original work shall vest in the author, and in the case of joint authorship, in the co-authors of the work. It's therefore critical to identify who the author is. In respect of a computer program, the Copyright Act states that the author is the person who exercised control over the making of the computer program. Where the work is created in the course and scope of employment, the employer will hold the copyright. When a computer program has been commissioned, the person commissioning the work would be the author. So there is some provision already in our legislation which allows for protection of such creations. So the Copyright Act defines an author in relation to various works as the person. Legal persons, both natural and juristic, does not just refer to humans. But AI was not considered, of course, at the time of drafting this in 1978. If the machine is truly autonomous, the work is technically original. So who then is the author? Legal lacunae that need to be developed to keep up with technology. So there is a gap in the legislation which needs to be addressed by the legislators. And that is the end of the presentation. My thanks to Tecla Spiller, who shared this knowledge with me, and otherwise I would not have been able to do this presentation.